order this evening's meeting of the North Canton Zoning and Building Standard Board of Appeals. Welcome everybody this evening. Would you call the roll, please?
Mr. Mahalson?
Here.
Mr. Bacon?
Yes.
Mrs. Weaver?
Here.
Mr. Zollinger?
Here.
Mr. Klein?
Here.
All in attendance, Mr. Chairman.
Thank you. Just a few preliminary matters. If you have a cell phone, smartphone in your pocket, purse, whatever, please put them on silent. Thank you. I see we have one videographer, which is on a tripod this side, and that's fine. I would just ask that you remain stationary. Appreciate that cooperation. The first thing on our agenda this evening, before we get into tonight's substance, if you will be the approval of what is effectively the transcript from our last proceeding in October 2015. Everyone's received a copy. Are there any corrections to the transcript or additions that we would like to make? There being none, I'd entertain a motion to accept the transcript as submitted.
Yes, sir.
Moved and seconded. All in favor signify by saying aye.
Aye.
Opposed? Thank you. The minutes of the transcript have been approved.
Thank you.
Thank you. We have one item of new business this evening. Would you introduce it, please?
Application number CBOA 240-16. The appellate is Montabella Homeowners Association. Appeal of the Planning Commission's December 9, 2015 approval of a site plan and conditional use permit for the erection of a wireless telecommunications facility on the property of First French Church located at 5455 Market Avenue.
Thank you. This is a unique issue for this board to hear. We're not going to proceed generally as we normally do, but rather this is in effect an appellate argument. We are going to be confined to the transcript proceedings and the record that was made at the Planning Commission. And what we're going to do is we're going to hear arguments of counsel on the issues that have been raised by the appeal, and then we will decide whether to grant the appeal or to in fact affirm the Planning Commission. But we also have a motion that was filed on behalf of the tower company to dismiss the appeal on the basis of lack of standing. I believe was the primary stated reason. The lack of jurisdiction and lack of standing is the argument made by the tower company's counsel. We're going to hear that first. Each side will have 5 minutes. The appellee, and the moving party will go first, and then a response by counsel for the appellant in the appeal. Give also the brief rebuttal to the moving party since they have the burden on that issue. We will then discuss the issue. We will probably ask for comments by our counsel, Mr. Fox, after which we will rule on the motion, after which, assuming that the motion was not successful, we will then move on to the substance of the appeal. And we'll have that in effect an appellate argument. The counsel are familiar with this process, but we will have, we're not taking any evidence this evening, so everyone understands that this is an appeal, and we'll confine to the record, which we all have, by the way, from the Planning Commission. We'll hear arguments from the parties. We'll give the appellant 15 minutes. If the appellant wants to break that down and save 5 minutes for rebuttal, you're entitled to do so. And then the appellee will be heard. And then any rebuttal, if the appellant has reserved time for that. We'll then have a discussion amongst the members of this board. We may ask counsel questions during the presentation. And then we'll have a vote pursuant to the appeal as to whether to grant the appeal or deny. And I think as counsel are well aware, our decision is also appealable to the next level in the legal process of an issue like this. So with that explanation of how we're going to proceed this evening, I'd ask the moving party to step forward. Counsel, please introduce yourselves and then proceed to address the issues in the motion.
All right, good evening. Chairman Klein, members of the board, my name is Jim Matthews. I'm here tonight on behalf of the appellee in this proceeding, which is Tower Code, the applicant in the matter before the Planning Commission below. I appreciate the opportunity to address the motion to dismiss that we filed first. That does seem like a logical approach to the matter that you have tonight. I don't know how much background you need. I will not belabor the background. This matter does involve an application for a conditional use permit and for site plan approval for the installation of a cellular telecommunications tower. Pursuant to the local ordinances, that use is a conditionally permitted use, and a conditional permit must be obtained from the Planning Commission. Thus, the procedures were undertaken before the Planning Commission. The matter that was conducted before the Planning Commission is, of course, important for you to consider. There are a number of different items that trigger the authority or jurisdiction of a Planning Commission. Sometimes they hear things that are almost legislative in function or advisory in function, and those matters then proceed on to the City Council for further consideration. The Planning Commission also occasionally exercises quasi-judicial authority. In the instance of this matter, with the application for the conditional use permit that was submitted, that was a quasi-judicial hearing that they heard. And I'm sure you're all familiar with the fact that the record is quite extensive. I believe there was a hearing that lasted over 3 hours in which everyone who wanted to oppose the tower company's position was given a full opportunity to develop whatever evidence they might offer. And bits or pieces of that record may be before you tonight.
Or should
To get-
we have the whole record.
Okay, very good. Thank you, Jim.
Word by word, little by little.
All right, just what you wanted, yes. In any event, let's jump then to the issues that I've raised in the motion. There is a single applicant or appellant that has filed a document with you captured as a notice of appeal, and that's the Montabella Homeowners Association. Part of the brief that we filed recognizes the fact that at one point in time, Montabella Estates was filed with the Ohio Secretary of State and operating as a nonprofit corporation. It's also undisputed that status was canceled in 2014, and there's been no effort to revive it. So clearly, in terms of its former status as a recognized nonprofit corporation, it has no standing to be involved in this proceeding. There's a statute that we've cited in the brief. I don't need to elaborate on it. Essentially, once the articles of the corporation of nonprofit corporation are canceled, the only function that the corporation can serve is in winding up its affairs. Otherwise, the response brief that's been filed by Montabella suggests that it has authority, since it's a defunct corporation, to act before you as an unincorporated association. I can tell you, and Chairman Klein, if you don't mind, I do have a very brief supplemental reply that my associate Tanya has. She can distribute for you.
Yes.
And it,
Yeah, please do. Give a copy of them, please, and a copy for us to.
that'd be fine. Make sure the chairman gets it. Okay, thank you. In any event, the case law is quite clear that in the zoning context and in the context of an administrative appeal, which this matter is, an unincorporated association does not have standing to pursue relief in an administrative appeal. And we've cited the authority to you there that stands to that effect. Some of this case law dates back well into the 60s and 70s. The cases we've cited for you are more recent ones from 2002 to 1986. But all of the law from at least 6 of the appellate jurisdictions in Ohio recognize that principle. Again, it's our position that the Homeowners Association has no capacity to be making any arguments on appeal for you. I'm going to briefly then summarize on my final points relating to jurisdiction. The 2 matters that you need to operate under, of course, are your city charter and your city ordinances. The ordinance relied upon by Montabella is 1179.01. It's our position that that ordinance does not give an unincorporated association capacity or standing to bring an appeal before this board. The ordinance speaks to a person, firm, or corporation having authority if other provisions are met to bring matters before you. An unassociated corporation is not a person, firm, or a corporation. The other important provision of that statute is that it gives you authority to review matters as an appellate body from a decision of the superintendent of zoning authority or from an administrative officer. Interestingly enough, in the brief that was submitted in response to our motion, all of a sudden that word officer became plural instead of singular. In the ordinance, it's singular. If an officer who has zoning authority makes a decision that someone disagrees with, that is a decision that can be appealed to the Board of Zoning Appeals. A planning commission sitting as a quasi-judicial body is not an administrative officer taking such a decision that can then be appealed before you. Our final point was then under the charter. While the appellants don't address the charter at all, they breeze through that in their response brief. I think it's important to nevertheless be complete for you for your consideration. And the charter only speaks to your authority being over such matters that relate to exceptions to or variations in any of the regulations found in the zoning code. Here, the matter brought before the Planning Commission did not in any fashion involve any exception or any variance or anything along those lines. So even if this board had some authority to look at matters generally from the Planning Commission, in this instance, it's not a matter that was decided that should probably come here. So again, we don't need to belabor the points. We have submitted the brief. We appreciate your consideration of the additional brief that we submitted tonight. And Chairman Klein, unless you have any further questions at this point, that's all I have.
Okay. Anybody have any questions, Mr. Chairman? Thank you.
Thank you.
Before you begin, I'll let you know that we're going to give you just a little bit more than 5 minutes in management, or just a tad. That's just a tad. So just a bit more than about 6 minutes or so. Please go ahead.
Thank you. Attorney Gilman, I represent the Montabella Homeowners Association. I want to thank you all for your time and allowing us to come before you with these arguments. In response to Council Matthews' arguments in his motion to dismiss, the first one, as far as the expiration of Montabella as a nonprofit corporation, it's not contested by us or my client that that did occur in 2014. We are asking this board to hear this matter on the basis of those individuals that make up the Montabella Homeowners Association, some of whom are here tonight. With regard to the second issue brought up, that this is not the proper body to hear this particular appeal, that it must be from an administrative officer, I would submit that in fact the members of the Planning Commission are administrative officers in their own right, and that we in fact are in the proper court. It's stated in the North Canton City ordinances that the zoning board has the power to hear and decide appeals where it is alleged there is an error in any order, requirement, decision, interpretation, or determination made by an administrative official and the administration or enforcement of this ordinance. We would argue that we are before the proper court. In opposing counsel's motion to dismiss, they also suggested that the proper avenue to go to from here would be common pleas court, citing that in a final action, the proper relief in appealing an administrative decision is to go straight to common pleas court. On behalf of my clients, we would argue that the decision of the Planning Commission was not in fact a final action as defined by the Ohio Revised Code. The Ohio Revised Code defines a final decision as an order, adjudication, or decision determining rights, duties, privileges of a person, but does not include any order, adjudication, or decision from which an appeal is granted by rule or ordinance. Our argument or our contention is that the ordinances of the City of North Canton grant us this appeal to be before you, arguing the Planning Commission's decision. I would ask that you make a ruling on the opposing counsel's motion to dismiss regarding these issues, and thank you for your time.
Before you step down, any questions for this council?
Mr. Boylan, I have a question regarding you're asserting that Montabella is now an unincorporated association. Is that correct?
That is correct. There's no denying that.
Do you have any, or is there anything in the record giving the association authority to bring this or to contest the application or to prosecute this appeal, meeting minutes?
In the record from the planning commission meeting,
Yes.
there were parties present there that were representative of the homeowners association, members of the homeowners association.
Okay, and I just want, I'm trying to figure out what authority they had as managers or members of the association to bring this, you know, to contest the application and to bring this appeal. Is there any evidence of formalities that were observed by the association, any meeting minutes, anything like that, any votes taken? Do you have anything in the record to show that the association had the authority to be a party to this case?
With regard to them being an established entity, there's nothing in the record at the planning commission, no, but outside of that, they still operate.
Okay.
Other than this one individual appeal, has that association done anything else other than attempt to wind up its affairs?
I cannot comment on that.
Okay, you don't know. Okay, last question I have for you. Under 117902, subpart B, and maybe you addressed this and I missed it, so I apologize. What your appeal has to also includes a provision of the ordinance from which the appeal is sought. Which provision of the ordinance is the subject of your appeal?
There were actually three of them. The three provisions. One dealt with the requirements for conditional uses, and it listed about 5 different requirements that had to be met. One of them dealt with property values. Another one dealt with the requirement that there must be an explanation about co-location. That's in the ordinances as well. And then the last one dealt with the requirement that permission from the landowner has been shown to the planning commission. Those were the 3 provisions. I can't cite them right now, though.
That's okay, thank you. Anything else, sir?
No, thank you.
Thank you. Brief rebuttal, Mr. Matthews. Very brief.
Thank you, Chairman Klein. To answer the question directly, there is nothing in the record about the capacity or status of the homeowners association to contest the application. While the motion is generally something that has the burden resting on the party making the motion, under Ohio law, standing is an affirmative burden of a party claiming it. And here, there's been absolutely no effort whatsoever to make a demonstration that would comply with the associational standards that are submitted in the brief. And there's further no suggestion at all of any direct effect or direct identifiable injury to the homeowners association that would afford it standing to pursue any form of an appeal from the Planning Commission ruling. In terms of the provision relating to finality, the important clause of the statute speaking to finality is only if something is subject to further appeal by rule, statute, or ordinance in which there is a hearing to be afforded is something not final. Our position is there is not a single provision of the city charter or ordinance that allows a quasi-judicial matter to be heard and decided in that fashion by one panel and then be reviewed in a quasi-judicial fashion again by another panel. There isn't any ordinance that we've identified to that effect, and importantly, the appellant has offered no authority for that proposition before you tonight.
Thank you.
I have a question.
Sure.
I took a quick look at the brief, your supplemental brief.
Yeah.
And I don't know these cases, I'm not familiar with them, but
Sure.
I am familiar with Chapter 1745, Revised Code, that governs unincorporated associations.
Right. And
it gives them the right to sue or be sued. How do you reconcile that with what these cases say?
It's actually addressed in the case law. The old version, 1745-01, used to be the provision that specified that an unincorporated association could sue in its own name or be sued. I think the current version is 1745-11 that has that language of suing and being sued. But the way the courts look at it is, in order to have standing to appeal, it's a completely different matter. You have to meet the statutory definition of a directly affected party to file an administrative appeal. That's why the courts, even though that statute is out there that says right to sue and be sued, that does not control or authorize administrative appeals in the zoning setting. That's how the courts have addressed that.
Okay. And was standing addressed at all for the commission? I looked through the record, I read the transcript, I didn't see where that was. Was that discussed? Was this issue discussed about the articles being canceled? I didn't see it.
It was not, because there was nothing other than the representation that it was a homeowners association. There was no challenge to its existence that evening. When they filed this appeal was when I did the research and found that their articles had been canceled, and it brought the issue before you for your attention. Now, importantly, of course, standing is a matter that can be raised at any point in any proceeding, even in a court proceeding. An appellate court has the authority even to look at whether standing was proper at the commencement of an action, even trigger jurisdiction in the first instance.
Well, that was my next question. I wanted to verify, we deny your motion. We just want to hear everybody out, and let's let everybody have their day before the Board of Zoning Appeals. I mean, that is, you can raise standing further down the road, correct?
I could and certainly would, that's correct.
Thank you. Discussion. Clint, you want to comment on your take on what we've heard with respect to the motion? We will make this reasonably brief. Go ahead.
The standing issue is of concern, but I do, it wasn't raised before, and I do, because Chapter 1745 does give unincorporated associations a lot of latitude. If you read the entire chapter, I would be inclined to deny the motion to dismiss, so and let everybody out on the issue of the merits.
Sam? Comments? Questions? No? Brian?
No.
On my own behalf, I would say I find that the argument about standing compelling, and not having had the opportunity to see the cases that were cited here, and I have no doubt that they say what they say. As a practical matter, I believe that since standing in jurisdiction, and I agree with counsel, can be raised at any point in time. One, I don't think we're violating the idea that we stay within the record of the Planning Commission. I also think it's an issue that can be resolved later on. Later on, it may be moved, quite frankly, if it goes to the common pleas level. So, although I have serious questions about the standing of the once association and now an unincorporated association, whoever they may be, I would be inclined to move on to the merits myself. So, I would entertain a motion with respect to the motion.
I would make a motion to deny the motion to dismiss the appeal.
The second? Made and seconded. Any further discussion? Call the roll, please. And a vote in favor is a vote to deny the motion to dismiss while standing in jurisdiction.
Mrs. Weaver?
Yes.
Mr. Mahassan?
Yes.
Mr. Zollinger?
Yes.
Mr. Bacon?
Yes.
Mr. Klein?
Yes.
Thank you, Board.
Thank you, Council. Well, the motion is to dismiss as being denied. Let's move to the merits. As I said earlier, we'll give each side 15 minutes, and the appellant can reserve 5 at the end for the end, if you so desire. And be mindful that we do have a record. We've had this for quite some time now, so it is our practice to become familiar with the records of these matters. So I would encourage you not to use your time following that earth, so to speak. Council for the appellants, please.
Thank you. Once again, my name is Aaron Violan, counsel for the Montabella Homeowners Association. We filed this appeal regarding the Planning Commission's decision to approve the conditional use site plan for a telecommunications tower at First Branch Church. In the appeal that was filed, there were 3 main arguments that we asserted. What I would like to ask the zoning board to do is to, stand in the shoes of the Planning Commission. Under the North Canton Ordinance 117907, it does give the power of those same officers of the planning commissions to the members of the zoning board of appeals. Our main argument in asserting all three of these statements is that the decision of the planning commission was against the weight of the evidence based on the record itself. The first argument that we made deals with the issue of co-location under the codified ordinances of the city of North Canton. Okay, the applicant has to provide an explanation as to why co-location with existing facilities is not possible or why other nearby structures cannot be utilized to house the antenna. On the record, at the Planning Commission meeting, Tower Code did present some evidence with regard to the second prong of that as to why other nearby structures could not be utilized, in stating that since 9/11, water towers are no longer used and they are expensive to repaint, or it causes a shutdown in service when they need to be repainted. And there was also brought up an electronic transmission line as a potential structure to house the antenna. And they did present evidence that that can be very expensive to use those particular structures to house antennas. However, when it comes to the explanation of why co-location with existing facilities is not possible, there wasn't a whole lot on the record. I believe Mr. Woodward explained to the Planning Commission what a gap in coverage was and asserted that there was a gap in coverage at this particular spot based on propagation maps that were given to them by Verizon Wireless. However, it was not stated by him or Mr. Pitcher at the Planning Commission meeting that any attempts were really ever made to co-locate. It was basically, they got these maps from Verizon and telling them that this is where this area needs to be fixed. And it just, from the record, like I said, reading through it, it doesn't appear that they attempted to co-locate. And they didn't give an explanation why co-location wasn't possible other than they stated that there was a gap here and this needs to be filled. As indicated in opposing counsel's response to the appeal, they indicated that the City Ordinance 115705 allows the Planning Commission to hire consultants, outside consultants, to see if co-location is possible. In the response to the appeal, they indicated that the fact that this wasn't brought up meant that the Planning Commission must have been satisfied with the explanation. However, it's not really clear on the record whether they were satisfied with the explanation or whether or not they had knowledge of this ability of them to do, due diligence in following the statute as to whether or not co-location was available. We would hope that if they were aware of that and weren't satisfied, they would have asked that to be done. I believe the statute reads a third-party independent individual can be contracted out to determine whether co-location is possible with other towers in the area. That's what the co-location means, as far as putting their antenna with other companies' antennas. The second issue that we brought up dealt with the property values. Under 114502, it states that the Planning Commission shall find adequate evidence that the proposed use, the conditional use, will not be detrimental to property values. There was a bit of evidence proposed at the Planning Commission meeting that consisted of a couple of photographs being shown to the Planning Commission and a spreadsheet. What they did was they submitted a spreadsheet with all of the ordinances on the left side, the requirements of the ordinance, and on the right side they gave some sort of explanation. When it came to 114502, the property values, the explanation was that the tower will be 301 feet away from Montabella Estates and that it will not cause any interference with the property's value. there's nothing else on the record, no statements by individuals asserting that a tower being put up there would not be detrimental to the property values. And in the response to the appeal, Tower Code suggests that that should be a burden that's placed on the individuals opposing it. However, we would argue that to comply with the statute, that burden would fall on the applicant to show that it's not detrimental to property values. At the Planning Commission meeting, we had a couple of members of Montabella Estates briefly testify that they felt that it's going to affect their property values in a negative way. However, I feel that pictures of the tower and a brief statement that it's 300 feet away from Montabella and that it won't interfere with the property values is not adequate evidence, nor should it be considered adequate evidence that the use will not be detrimental to property values. Briefly in researching similar cases, I see Planning Commissions, the proponents or the applicants at the Planning Commission meetings will have expert witnesses come in, real estate appraisers, to testify that in this particular instance, this set of circumstances, this will not affect a certain property value. That obviously that burden was not met, nor was anything close to that met. The last argument that we made, and this was brought up, they went into it pretty in depth at the Planning Commission meeting, dealt with whether or not there was satisfactory documentation that the owner of the property, First Friends Church, was allowing easements to Tower Co. If you weren't aware, there was a proposal before, or an agreement between the church and Tower Co. for them to put the tower in a certain spot, and Tower Co's council produced the documentation of the lease agreement itself. However, there was language within that lease agreement that suggested that First Friends Church had the final say. Under Section 6E, it basically stated that any changes or final approval of where the tower is to be needs to be consented to in writing by First Friends Church. And it was brought up and addressed by Law Director Fox that perhaps this is something better served in common pleas court if First Friends would like to pursue it. However, I would argue that the Zoning Board of Appeals has power to make that decision, that it did not in fact create an easement. That would not take away the right for Tower Co. to pursue that in common pleas court as well. Once again, I want to thank you for hearing our argument, and we would ask that the conditional use permit and the site plan approval be denied by the Zoning Board of Appeals. Thank you.
Thank you. By the way, Council, you didn't use all your allocated time, so you have a few minutes for both if you'd like.
Okay.
Council's done.
Thank you. Let's start with some of the introductory remarks that are very important for you to consider if you're going to address anything related to the merits of this matter. You were asked by the Appellant's Counsel to effectively stand in the shoes of your Planning Commission. There's no authority for you to stand in the shoes of the Planning Commission. Also, you've been asked to essentially substitute your judgment of the evidence that was submitted for the judgment rendered by the Planning Commission. There's no standard in the ordinance, there's no standard in law for you to sit and simply substitute your judgment of the evidence for the judgment of the Planning Commission. The law is actually quite to the contrary. We've had a full and open administrative quasi-judicial hearing before a board that had jurisdiction to hear the matter. That board gave everyone an ample opportunity to present their cases, to develop a record on whether or not that board was satisfied there was adequate evidence to meet the various provisions of the ordinance. It's for that board to make those determinations. At any stage of an administrative appeal beyond that board hearing that matter, the law makes it clear that there is a presumption of regularity in that proceeding. In fact, the decision from that administrative agency carries with it a, quote, strong presumption of validity. One of the matters I addressed in the briefing here is my concern that nobody is really quite clear what is the standard we're looking at tonight. It is certainly not your board standing in the shoes of the Planning Commission. And it is also certainly not you reviewing the record and hearing these arguments and substituting your judgment for that of the Planning Commission. I submit to you that the law, which should be applied here, is that you need to look at the fact that the administrative decision from the Planning Commission is entitled to a strong presumption of validity, and the burden of proving any invalidity rests upon the contesting party, the appellant. Let's look then at some of these issues that have been raised. The issue of co-location and whether there was any evidence of a gap in coverage. I heard the appellant's counsel state to you that while there was evidence of why the water tower was not a suitable co-location, and he also conceded that there was also evidence explaining why the electric transmission line was not a feasible co-location, he yet suggests to you that there had to be something more. Those were the two propositions raised before the Planning Commission. Why aren't you looking at the water tower? Why aren't you looking at the electric line? There was explanation offered for why those two options were not feasible. And then, quite frankly, and interestingly enough for tonight's purpose, the appellant's counsel also candidly conceded to you that there was evidence from Mr. Woodward about the gap in coverage. That Verizon and TowerCo aren't simply coming into North Canton to build a tower for no reason, but yet there's been an analysis of a coverage gap that will be solved by building a tower on market at the location proposed. Mr. Woodward clarified with no uncertainty whatsoever about the propagation map that was prepared that clearly shows the gap in coverage to be solved by this tower location. Conceded by the appellant's counsel. Now, what else is important about the record? There is nothing competing with that. Nothing. There isn't even somebody coming up and speculating that, well, it's really not necessary for this, that. There's certainly no evidence from any actual witness who had personal knowledge or background to challenge Mr. Woodward's testimony before the Planning Commission about the reason for this tower location. Without any competing evidence, and with there being the acknowledgement that there is evidence on both of these key points, and given the presumption of validity to the Planning Commission's decision, I submit there's no basis whatsoever to reverse or otherwise affect the Planning Commission's decision. Let's jump to the other two issues that have been raised in the appeal. One relates to property values. I also heard from appellant's counsel that, well, there was some effort to offer explanation, meaning there was, in fact, some evidence offered to explain how, in our position, this was not going to adversely affect property values. So it's not like you have a blank, bare record. You have an appellant acknowledging there was evidence submitted to substantiate our propositions. Now, more importantly, on the issue of property values, the Homeowners Association made no argument whatsoever before the Planning Commission relating to property values. That's the state of the record. While standing and jurisdiction issues that we've covered and addressed are never waived in proceedings, one thing we all know is if you don't present something of substance at the first opportunity to do so, you do waive that matter. And we have objected in the briefing to considering issues relating to property values at this point raised by this Homeowners Association. Not raised below, inappropriate to raise it at this late opportunity. Regardless of that point, let's look at the record dealing with property values suggested by the, well, not by the Homeowners Association because it didn't raise the issue, but suggested otherwise in the record. There were a couple of residents who stood up and offered the proposition that they felt, I think that was the term used, felt was the characterization of their testimony, felt that their home values might be adversely affected. That is not evidence. I'm not making up that rule. I'm not here just suggesting that's the rule we follow. That's the rule that the courts look to. That when people come to administrative hearings and are simply offering, even though they're heartfelt, even though they're intended, but it's just their personal beliefs, it's their personal opinions about something that might happen to them, that is not evidence. And I can tell you one thing that's really important in the tower situation is, in this context, that clearly would not be substantial evidence upon which to deny a tower applicant's permit. The case law we have cited in our brief is absolutely clear that under the Telecommunications Act, it is well recognized that mere generalized concerns of residents relating to things such as aesthetics and property values based upon conjecture and speculation are never substantive evidence sufficient to deny the telecommunications company a permit to operate in a local area. So again, despite the fact they never raised it, there's no record competing with the acknowledged evidence that we offered for consideration by the Planning Commission relating to property values. Finally, this issue of the lease. And by the way, that's what you have on the record. You don't have a suggestion of an easement or a suggestion of some right to use the property. You have a valid and existing legal contract in the form of a property lease between the church and our client. The suggestion, and by the way, another issue that was not addressed at all by the Homeowners Association at the hearing before the Planning Commission. My position is it's waived. But nevertheless, I'm willing to address it because the record addresses the lease. The lease is clear. The lease doesn't just somehow indicate that, well, at the end of the day, the church has final say on the location of the tower. The actual terms of the lease that we address to the Planning Commission are that we have the right to use the property for the tower. We have the right to identify the location where the facilities are going to be. And at the time of construction, there will be a final plan submitted for the church's approval. And that approval cannot be withheld for some unreasonable or irrational reason or for, to try and get more money for the lease. It's very standard provisions in a lease that they'll consent to the location. The bottom line is that entire provision that was addressed before the Planning Commission was addressed by the fact that the lease itself controls and says that approval is not required until the time of construction. What's another important provision of the lease that hasn't been addressed to you by the appellant? There's another important provision of the lease. It says that the church shall cooperate with Tower Code in its efforts to get whatever governmental approvals it needs to proceed under the lease. Now, I'm going to reiterate my position that I raised at the time of the Planning Commission, and I think it was reinforced by your law director, Mr. Fox, that quite frankly, none of these issues were justiciable before the Planning Commission, and none of these issues are really justiciable before you. I appreciate that it's good for background, and I'm glad that I've had the opportunity to clarify things for you. But that lease gives Tower Code every legal right as we stand here right now to use that property once it has the permit issued from this city to proceed with construction of this tower. I'll summarize. I have a couple more minutes, Mr. Pond.
Yes, you do.
Thank you. Thank you. I'm not trying to belabor things tonight. I know that you have something presented to you and you want to be able to fairly and fully consider it and apply the correct rules of law to reach a rational decision. I fully understand that you want to do that, and that's what you should be doing, and that's why it's good that we're taking this opportunity to review everything. But the bottom line, when you look at this record, it does cover all of the necessary points under each provision of the resolution. We went through the ordinances in exhausting detail and prepared a spreadsheet. I forget what we may have characterized it as or called it that night at the Planning Commission. But it literally tracks each provision that had to be satisfied, our position on how it was satisfied, and and offered that for the consideration of the Planning Commission. Their decision being entitled to a presumption of regularity and a presumption of validity. And I submit to you, nothing has been demonstrated. It's the burden for an appellant to come here and tell you where the error is. The error is here, the error is there, there's something substantively missing, or procedurally unfair, something that was missing. And I submit to you, I haven't heard any of that. Two of the points altogether were waived, weren't even addressed before the panel below. And on the issue of co-location and need for this tower, we heard the concession from appellant's counsel that, well, there was evidence submitted by Tower Co on those points. On this record, if you want to look at that full record, I submit that it more than reasonably and rationally supports the necessary evidence standard for the Planning Commission to authorize the conditional use and to have also approved this site plan, and that its efforts and its work on this matter should not be disturbed upon this review. That's all I have, Mr. Klein, unless you or any of the other board members would have any questions.
Does anyone have a question for council?
That's not?
Anybody else?
No? Okay, thank you. Oh, I'm sorry.
I have a question. My only concern is with 115705 on co-location. I really haven't read and heard anything substantive that tells me that there is another location applicable for this town, such as the water tower that is brought up.
The two locations that were discussed were, one was the water tower and one was the transmission lines. And the water tower is not feasible because of its accessibility and lack of accessibility. And the fact that in our world we're living in now, after the terrorist attacks of 9/11, there's a preference to stay away from public facilities like that are subject to attack. That's why they're not preferred for co-location of cellular telecommunication facilities.
Is there an AT&T antenna on that water tower?
There is a pre-existing one.
And is it accessible?
I'm sure it's accessible, but I'm also sure, as the testimony was offered, that during times of any repair, painting, or what have you facilities, there has to be a downtime in service, and the preference is not to have those downtimes in service. You don't know when a dramatic 911 call is going to come through, and you want to avoid those opportunities for dropped or missed calls. That was the testimony offered by Mr. Woodward. You want to avoid those situations, and thus it's not feasible to use a water tower. There was nothing competing with that evidence for the Planning Commission to weigh or consider. Rather, they heard the testimony, and they drew the conclusion that that was the requisite adequate proof they needed to be satisfied that in this instance that water tower is not a
Did the
feasible
Planning
alternative.
Commission vet any of that information as far as shutdown? If the water tower had any payment, did anyone vet that information?
I'm sorry, did anyone vet it?
Did anyone look into it as to whether that's a true statement?
Well, obviously they vetted it because they deliberated on the matter. They sat, they heard that evidence, they deliberated, and they made a decision. And again, based upon some of the case law we've cited, it's not like they had to go through each bullet point and make a raw decision. Their decision is to approve this conditional use, and inferred or implicit is that all of the requisite standards were met by the testimony. That board was satisfied this was enough evidence.
So you're saying conditional use then actually trumps this board as far as pertaining to the ordinances and in
I'm
1157?
I'm suggesting, and I've made myself clear, the Planning Commission has the plenary power to consider a matter relating to a conditional use for a proposed cellular telecommunications tower. Their judgment is entitled to the presumption of regularity and validity, and to the extent you're reviewing it, your review should not be to weigh the evidence, reconsider the evidence, substitute your judgment on the evidence, but rather to look at the regularity and make sure that what was done below was rational and reasonable, and not some gross abuse of its discretion, of the Planning Commission's discretion.
Thank you, sir.
Thanks again.
Council, would you like a few minutes?
Yes, briefly.
Thank you.
First of all, with regard to the power of the zoning board of appeals, as I suggested, to stand in the shoes, for lack of a better word, of the planning commission in reviewing the testimony. I just want to cite section 117907 of the codified ordinances of the city of North Canton, which states, the zoning board of appeals may reverse or affirm wholly in part the decision being appealed, and to that end shall have all the powers of the officers from whom the appeal is taken. So I believe that the zoning board of appeals does have that power to stand in their shoes and make a decision based on the evidence that was given. With regard to opposing counsel's argument that the co-location prong was satisfied, I think there's some confusion. In the ordinance, it says that they must give an explanation as to why co-location with existing facilities is not possible, or why other nearby structures cannot be used. I conceded that prong 2 of that, other nearby structures cannot be used. Evidence was given of that with the water tower and the electro tower. However, co-location with other facilities, so existing antennas that other carriers have, or existing towers that other carriers have antennas on right now, there was no evidence given at the planning commission meeting that they tried to utilize those, attempted to utilize those. We would ask that, the zoning board of appeals, if nothing else, on behalf of my clients, would verify the fact that co-location is not possible at this point by hiring an independent expert to determine that it is not possible. And then lastly, with regard to the argument that the property values and the contract were waived, these were factors that were required to be considered by the planning commission. They're listed in the code as required to be considered. I don't understand how my client, or me on behalf of my client, could waive those factors if they must be considered. Once again, thank you for your time, and we ask that the conditional use be denied and the site plan be denied. Thank you.
Thank you, Johnson. Before we go any further, I would just like to ask Mr. Fox to opine very briefly on whether, specifically addressing whether the decision, or the procedures and the decision and the resulting decision of the Planning Commission were unconstitutional or illegal, using the standards set forth in the revised code for a reviewing body or a decision of this nature. But I think we need to hear that from you, since although we have two lawyers up here, we don't really make kind of legal decisions such as that. So if you could advise us on the record, we'd appreciate it.
Of course, there was nothing that I found in the record or sitting through, as was explained, was a 3-hour hearing, as well as with the record as a whole, all the evidence that was presented. There's nothing there that I've seen that would lead me to believe that anything that was presented was illegal or unconstitutional. And if I may, just for a couple of issues on what was raised.
Sure.
First of all, the issue of standing in the shoes of the Planning Commission. Common law, judge-made law on these issues has been quite clear on hearing the appeals of administrative agencies. You're an administrative agency yourself. You're actually hearing the appeal from an administrative agency, the Planning Commission. But those rules would still apply to you in looking at the record and making determinations based on what occurred during that hearing. And the courts have been quite clear, because there's a federal act that's involved with this, so it also applies to both federal and Ohio law on this issue, but they have been quite clear in reviewing the administrative decisions, and they provide that you may not substitute your opinion for another administrative agency, and it's clear that that administrative agency is due deference for resolving evidentiary conflicts, because it's the fact finder at that point, and just as though you were able to observe the, not just the comments, but the mannerisms, the conviction, and so forth for those that were speaking this evening, that same type of deference is due for the fact finder for the planning commission. They were here, they were able to observe those things personally from those that were offering evidence, and so that's why you're not permitted to substitute your opinion for that. You're to look at the entire record and then base your decision off of that. Another provision with the issue of property values, and understand that where federal law and a local administrative ordinance such as our codified ordinance, when they conflict, federal law is going to usurp that. It's going to trump that. It's going to override it. And what's found, because there's such a multitude of these types of hearings in municipalities all around the country regarding this federal act, in 47 United States Code section 332C7, that's really the relevant part that comes into play. And there's a provision in there that states that a municipality ordinance or local law may not have the effect of prohibiting wireless service in a certain area. And that provision is in there in many cases for those municipalities that may enact an ordinance, certainly regarding property values, that would have the effect of keeping a cellular tower from being installed, say, within that area, within that neighborhood. So the federal act provides that you may not have an ordinance that would put something like that into effect. And so if there's an argument that North Canton's ordinance states that the burden is on, say, the tower company to prove that placing a tower in a neighborhood would not drop property values, I believe the federal act comes into play and then places that burden on the appellant, the one moving, stating that they believe property values would drop. And in the hearing before the Planning Commission, if you look at the total record, what you'll need to look for is evidence. Evidence presented by the appellant demonstrating that a cellular tower going into that location would indeed lower property values. Generally, what you'll find in cases where the courts have upheld situations where someone was able to demonstrate with evidence that property values would drop is when the person moving for that issue would bring in an expert, a real estate appraiser who has conducted a study or hired someone to conduct a study and present that evidence before the Planning Commission. Here, what was mentioned earlier in oral argument is that some individuals alleged that they believed that if a tower going into that neighborhood would take place, that it would drop property values. I don't know that there was more that was submitted, and those type of comments from what the courts consider laypersons and not experts, both state and federal courts have held that that's not sufficient evidence to prevent the award of a conditional use permit
for the issue of the drop of property values.
Okay, thank you, Mr. Collins. Mr. Zollner, do you have any comments or?
Yeah, I have a question for Mr. Viola, maybe. Mr. Viola, what you had asserted in your argument, if I hear the Director of Law, Mr. Fox, correctly, kind of contradicts. You indicated that the burden of establishing the diminishment or non-diminishment of property values is actually on the applicant in this instance, and not on the landowners. He says that burden actually shifts to the people who are asserting there's a lowering of property values to present evidence.
Yeah.
Do you have anything to contradict what he is saying in that regard?
Just to address that question, I believe that only applies when they show that the use is necessary in that particular area. This got brought up at the Planning Commission meeting, where the federal law allows local ordinances to be trumped if it's demonstrated that that area has a significant gap in coverage that needs to be filled. That's my understanding of it.
Okay, and are you saying there was not evidence of a significant gap in this situation?
I don't believe so.
And because there were, you're gonna have, I wasn't there, so I'm looking at the record. I see the maps of showing the white areas where there was no coverage or poor coverage. That wasn't evidence of a gap.
Well, the area that the tower fixed, according to the propagation maps, through the key of the propagation map, said that area had adequate coverage. So I wouldn't see that as a significant gap or gap in coverage.
It would show like the white area was poor, the yellow was good, and the red.
Correct. And when the tower goes into that area, it turned the yellow to a red on the propagation map from adequate to good.
Okay.
Anything else?
And
Sam? My own comments are briefly as follows. I think looking at the record as a whole, I don't think we can characterize the Planning Commission's decision as capricious or arbitrary. Indeed, it looks like they considered a great deal of evidence and arguments from people in the community, as well as the community or the property owners who claim to have been affected. And I think we do need to look at the record as a whole and determine whether it is supported by the evidence that's presented. And I take to heart the advice that there's a presumption of validity of the Planning Commission's decision, but we don't stand in shoes. I disagree with that assertion. This is not a de novo proceeding. We are looking at a record and deciding whether the record supports the decision. On the co-location issue, I personally don't believe that Verizon or the tower companies put this tower up on a whim. I believe that they believe that genuinely a need for it, otherwise they would be going all the trouble to do this. And so for that reason, I don't think it's fair to the appeal myself. That's just my opinion. Is there anything else from anyone? If not, then I'd entertain a motion then to either grant the appeal and overturn the decision of the Planning Commission, or deny the appeal and sustain the decision of the Planning Commission.
Before a motion is made, I would like to say the comment. I believe the standard of review here is abuse of discretion. We have to provide deference to the Planning Commission. We do not, this is not a lawyer's call de novo proceeding. We're not here to look at the issue of substitute our judgment before that of the Planning Commission. And because of that, I would support a motion to affirm the Planning Commission's decision. The evidence that they had before was sufficient for them to arrive at the decision to grant conditional use permit. So for that reason, I'm sorry, but I would make a motion to affirm the Planning Commission's decision.
A second.
Moved and seconded. Any further discussion? Let's call the roll, please. The motion is to affirm the Planning Commission and is to deny the appeal.
Thank you for that clarity.
Let's try.
Mr. Bacon?
Yeah.
Mr. Matheson?
No.
Mr. Klein?
Yes.
Mr. Zollinger?
Yes.
Mrs. Weaver?
Yes.
Thank you.
Thank you all. The appeal has been denied. I'm sure this is surprise represented by council. You know where this goes from here if you so choose. Thank you, gentlemen, for your presentation and your professional work and conducting yourself this evening. I appreciate that. I have one more item for not on our agenda, but I want to bring it up at this point, just for the record. It's been a few years. It's my understanding that we are required by ordinance to have a verbatim transcript of our proceedings, and obviously that we have to comply with that. But for purposes of the minutes of this board, we're requesting that we receive minutes to approve, which are a summary of our proceedings, which we will then review and approve at our next meeting. If there has to be a verbatim transcript made up at the request of somebody else in the city government or a member of the public, I think that's between them and the engineering department's administrative staff to provide that for somebody. But it doesn't mean that those are our minutes. So I'm requesting that we, at our next meeting, we have a summary minutes of this session and all future sessions. Is there any disagreement with the board on that point? No. So, Linda, if you take that into consideration, we would appreciate it. Thank you all. Is there a motion to adjourn? Moved and seconded. All in favor?